joined. I am Jeff Ernst, Chief Sales and Marketing Officer with Orange Tree Employment Screening. Welcome to today's webinar on the top 10 predictions for 2023 in the background screening industry. I am excited to have two members of our Higher Image division joining us today for today's presentation. They're the keynote speakers, in fact, Christine Canine and Laura Goebel. More about them in just a moment. Today's agenda, just a couple of things actually to make you aware of. There is a handout available. There will be continuing education credits available. That will be at the end of today's presentation. We'll send out a communication. The webinar is being recorded. The recording will be shared. And if you have questions along the way, both Laura and Christine have indicated they're very interested in having a conversation. So if there's something on your mind at the point where in a slide, in a topic, by all means, let us know what that question is. We'll do our best to interject at that moment. If we happen to get to it a little bit later, we will handle that accordingly. But nonetheless, submit your questions along the way. If for some reason we run out of time, or you think of something in the next day or two, send us an email. We'll answer your question at that time. We're happy to reach out and help you in any and every way we can. So with that, with a reminder to all of our existing clients, and for those of you who might be joining us for the first time or haven't yet worked with Orange Tree, our promise to you and all of our clients is that we will design a background screening program in your best interest. It's always about you. It's always about tailoring all of the different services that we have in our portfolio and our toolkit to meet your needs. Most companies, almost every company has a policy that's unique to them, and we have a program that's designed specifically to you. And at the end of the day, our passion truly is to become your teammate and trusted partner. A couple of things, just looking at the group that's registered for today's webinar, I thought it might be interesting to take a look at what we include in our program. It's not inclusive. It's kind of after you've chosen your services, after you've chosen your package, all the different program items that work for you. But just a reminder for some of our existing clients to take advantage of some of these capabilities, or for those of you who are looking for a new background screen provider, be aware of these are some of the things that you get if you work with Orange Tree. And notably, we've kind of highlighted some of those in orange, but oftentimes it's really important to know that you do get a dedicated account manager from Orange Tree. They know your account, they know who the decision makers are, who the key individuals are, they know your business. And so unlike a call center, where every time you have to start over, explain yourself, talk about your company and what it is you're trying to get done for the day, when you call Orange Tree, you talk to a dedicated account manager, and that individual already knows all that, and you can start where you need to in the course of that day. And it's much quicker for you to get the help you need, the answers you need, and ultimately the support that you deserve. With that, we offer training, not only at the time of our kickoff with an onboarding process, but throughout our partnership. And just a reminder, that can be something we schedule with a group, or perhaps you have a new recruiter, a new member of your team who just needs to get up and speed quickly with the Orange Tree portal. We're happy to work with you one-on-one, or also have some digital communications available for you also. And then just perhaps maybe what I'll do is save it for the next slide. The last two bullets may be new, maybe be less interesting for you all as talent acquisition professionals, as HR professionals, but nonetheless for your technology team. They probably want to know about single sign-on, multi-factor authentication, some of those key security features that really are an expectation for today's environment. We did offer those in the course of 2022. Most of our clients are deployed in those. So for those of you who are looking for a new provider, just understand that Orange Tree, SOC 2, Type 2 compliant, in addition to being PBSA accredited, we also have some of these latest security technologies that you would expect. A couple of highlights from last year: we offer a number of new integrations into our proprietary platform. You can see down there, Avature, Jazz HR, JobBite, Paradox. We have another one that we expect to release very soon, Greenhouse, and there'll be probably about another 4 or 5 exiting an executive meeting we had earlier today that we expect to release to the market this year. So we are always innovating, always bringing new technology to the market. If there's an integration that you need, let us know. Likely you already have it, or if we don't, we can build it for you and tailor it to your specific needs. We're pretty excited about the kind of there in the middle of the platform. We released and offered last year, offer today, I should say, an online buying experience. So perhaps you just want to go out and see if there's a package, if you're an existing client, see if there's a package, a set of services that are good for you. You can do so at your leisure. configure exactly what you're looking for, work with your client or your dedicated account manager, I should say, and they'll be happy to get the final pricing for you. And for those of you who are looking for some additional information, maybe you're just ready to go, you can configure your package. So we're pretty excited about that. It's been very popular and continues to gain more and more traction each and every day. As we look forward a little bit, we do have an exciting enhancement to our Candidate Connect, our mobile optimized candidate portal for all of your candidates. That's going to be released a little bit later this quarter. It seems like we're in second quarter, it's end of March. Maybe it's the same difference, if you forgive me for jumping ahead a couple of days, but nonetheless, right around the corner, that's going to be released. We do have an enhancement to our occupational health integration, which we're pretty excited about. It's going to create an even greater experience for you, for your candidates, and that's just right around the corner. Also, we actually have a couple of clients right now testing out to make sure that everything has the finishing touches that you would expect and deserve. And then looking ahead a little bit later in the year, a key project that we've been working on is a new portal. Our current portal does provide a lot of the information that you need right there at your fingertips, and where we're continuing to look at, is there a way to give you more information more easily? And we think we have some ideas on how to do that, and we're in the process of designing those, writing some code, and we would expect by the end of this year to start releasing that particular platform to our existing clients, in addition to those who come through our online buying experience. So a lot of things going on here at Orange Tree. This isn't intended to be an exhaustive list. Just want to let you know that our software development team is working. They're continuing to enhance what we have, make sure all of that obviously is operational. But as we look forward and in scaling with you, that we continue to have options that are most important, and it's something that delivers value to your background screening experience. So without any further ado, it is truly my great pleasure to turn over the microphone to Christine Kneen. She is a president of Hire Image, an organization that Orange Tree acquired last summer. They are fantastic. Laura Goebel, our director of compliance within the Hire Image division, and just great individuals. The exciting thing about having the opportunity to work with Hire Image, besides Laura and Christine, who you're going to hear from shortly, is the entirety of the organization. Talented individuals, years of experience in the background screening in the industry, and I think the shared values between the organizations is what's been really paramount to our collective success, and what will lead to even greater future success for the two organizations coming together as one. Focus on the client, what matters to you, and doing everything we can to deliver the services you need with the service and support that you expect and deserve on the back end. So with that, I'll turn it over to you, Christine, and Laura. Thank you very much for being part of today's presentation.
Great, thanks, Jeff. Appreciate that. Let me just get the screen here.
So let me stop my share, Christine, so you can take over.
All right, let's get this going here. Well, thanks so much, Jeff. I appreciate it, and it's just great to hear about all the innovation happening at Orange Tree, and I know we're excited to be a part of that. So for those of you who don't know me, Christine Kneen, president of Hire Image. I am former chair of the Professional Background Screeners Association. I've been working with Laura here for quite a number of years. She's our director of compliance. She's also actively involved with PBSA, the Professional Background Screeners Association. We're also, being actively involved, we're constantly on calls with the industry as a whole. So I'm on weekly calls with our government relations folks, which we could probably have a call every day. There's so much going on in the industry. So we have folks that represent us at the federal level, at the state and local level. So kind of have our hand on the pulse of everything that's going on within the industry, even internationally as well. So we came up with, and we tend to do this every year, we have our top 10 prediction list. So Roy Moore from SHRM actually wrote an article and has quoted our top 10 predictions for the last several years here. So I think we're pretty much right on, and we're hoping to get into that with you. And Laura, thank you for joining. I know Laura's kind of our expert in compliance, and she keeps our whole team FCRA certified, and we are nationally accredited as well. So thank you, Laura.
Thank you.
So let's just remind you all that we can't give legal advice. Everybody wants that legal advice. We just can't do it. But I really believe knowledge is power, right? You are on the front lines. So we're going to tell you some things today, and you might have in-house counsel. You might have outside counsel. This is such a nuanced law with background screening, and now there's so much with drug testing. So listen up and just know that you're learning here today, and hopefully you can go back to your team and you might have to make some changes, but feel free to reach out to, Jeff and his team, and we're happy to weigh in and help if there's anything that comes up. But again, we can't give any specific legal advice, but we're going to give you our take on things. So buckle up. Here we go. So our agenda today is going to be the top 10 predictions that we've come up with. We're also going to show you some industry resources, and then a little compliance 101, because we hate to leave a webinar and not touch on that, just because those lawsuits can get pretty darn expensive. So Laura, I'll pass it over to you to start us off.
Well, thank you very much. And I'm glad to be here today. All right. So there are several federal agencies who have been increasingly focusing on different areas related to hiring and background screening. So the CFPB, the Consumer Financial Protection Bureau, has been very active lately. In October of 2021, they ordered 6 large tech companies who operate payment systems to provide information about their business practices. And then in October of last year, they reopened the public comments period for people to make comments on what they saw and what they heard about this. But what does it mean for hiring and background screening? Well, these companies are being investigated for their acceptable use policies and their use of consumer data, which we know is going to trickle down into the non-financial sectors, such as background screening, which might then also give the CFPB further oversight over the industry. They've also been working with the FTC to expand their reach over additional types of companies, including background screening companies. This extended reach is going to add additional requirements on both the background screening companies and our clients, so be aware of that. And then the White House has issued a blueprint for an AI Bill of Rights. While it's not law, employers and others who use AI for hiring should examine their systems for systemic bias or discrimination. And this guidance covers several principles. It's safe and effective systems, algorithmic discrimination protection, data privacy, notice and explanation, and human alternatives consideration and fallbacks. There's several areas they're looking at. And then going along with the White House guidance, the EEOC has been very active regarding AI. They issued a technical assistance document late last year and then held a public hearing in January. We're going to go more in depth with AI later in the presentation, but this is a really big area of focus in the federal government right now.
Great. And then number 2 here, we have compliance challenges are going to increase with patchwork of state and local laws. That is not going to go away anytime soon. We continue to see that increase. And then the main thing to know, so we're going to talk slightly about ban the box, clean slate laws, pay transparency, and salary disclosures and marijuana laws. The main thing to know is there's no 2 laws that are exactly the same. So you can't just think you got it covered in one state and you're going to do the same exact thing in another state. And the scary part is it's not even just states anymore. It's cities, it's counties. So you really have to pay attention of where your offices are. And then in this day and age of remote workers, right? You have to really pay attention to the employment laws. Are you considered an employer in the state where you have a remote employee? So there's a lot to know. And that's why it's important to work with your providers, such as Orange Tree or Higher Image, to really know what those laws are and to make sure that you're in compliance with them. But it is your responsibility as the employer. So want to make sure, you don't lose sight of that. You can work with a provider, but, make sure you're communicating too. Sometimes I know for us, you all are moving so fast, you're, maybe buying a new company in a different location, opening a new plant somewhere. Just make sure you're in communication with your provider. It's really important to make sure you're up on those things. So, all right, let's start with ban the box. All right. Right now, ban the box is now turned into fair chance initiatives. That's what we're seeing. Most of you already should know what that is, right? It started years ago with ban the box. Take that question off the initial application. Has your applicant ever been arrested or convicted of a crime? And that kind of gives folks a chance to apply for the job and speak to you and show their credentials. So most of you, if not all of you, have probably taken that question already off the application. It's in many, many states. But what we're seeing is even some states that have started that trend are now going back and changing the laws. So just because you think you know what the law is, you might want to, check that out. So right now there's 18 states with some form of ban the box. And then, even in like Hawaii was the first state to start ban the box. And now in 2020, they passed a fair chance initiative, making it, kind of limiting what you, the employer, can see. So making it a little more stricter. Illinois is another example. They had a ban the box since 2015. And then here in 2021, they amended it to require employers to determine the relationship of the crime to the position that's being sought. So again, we're seeing a lot more of that. So pay attention to that. Ban the box, also called fair chance initiatives. Then you have the clean slate laws. This has really been taking off. And again, a lot of these things have, in theory, sound great and they make sense from a policy standpoint. But we all know when legislators get involved, there's a lot of unintended consequences. So basically, the clean slate laws are expansive record clearing legislation, and it includes automatic expungements a lot of times. So typically they're like minor crimes, maybe, a drug related, not selling, but, maybe possessing some sort of marijuana, things like that. So we could probably all agree, is that a big deal? No, like get rid of those laws, right? Get rid of those crimes. So currently right now there's 10 states that have these clean slate laws passed. But what I worry about is what happens when these laws pass, right? So they have great intentions, but there was just a study. So Pennsylvania was the first state to come out with clean slate laws, right? And in Pennsylvania, there was one county in particular that erased 80% of all their criminal records. So if you're in Franklin County, Pennsylvania, you should be worried. They're aware of it and they're trying to fix it. It's just how kind of they implemented the system, but that's what we're really afraid of. We've seen it in other states too, where they just start erasing some records and then you, the employer, don't know about it. So that's what we're concerned about with the clean slate laws, but we expect that to continue. The pay transparency and salary disclosure, again, another well-intentioned area, right? To fix the gender wage gap. So we can all kind of applaud that, but it causes some issues, and how it causes issues related to the background screening process is if you're doing prior employment, are you asking about prior salary? How are you asking about prior salary? At what point can you ask, if you can ask? So just make sure I know, like in our system, we've just removed, that salary question unless an employer opts in and specifically wants it, because you can in some states, right? So you want to be careful of that. Right now, that's in 17, there's 17 pending bills on pay transparency. So 2023 is going to be a big year for pay transparency. And then marijuana laws, which we're going to also cover in a little bit more, but the limiting of testing is going to continue. So from medical marijuana to recreational marijuana, when you can test, how you can test, the laws vary by every jurisdiction. So if you take nothing else out of today, just know that this is such a complex area. And again, as I mentioned to start off with, every state's a little bit different, or city or county. So if you haven't brushed off and looked at your substance abuse screening policy lately, I suggest you do. Because again, you could talk to different attorneys and get different advice, but a lot of folks say to have one drug screening policy and then have addendums for all the states you're in just to cover all those laws. So definitely, if you haven't looked at that, I highly recommend you do. So I'll just pass it back over to you, Laura, and get going on privacy.
All right. So yeah, background screening is being increasingly impacted by privacy laws. California, or right now we're tracking 43 bills related to data privacy. That's just a lot, so many. This year, several state data privacy laws go into effect, and we're seeing a lot of similarity between the bills, except California, but whatever. Okay, California previously enacted the California Consumer Privacy Act, the CCPA, in 2018, which gave California consumers greater rights over their personal information. In 2020, the voters in California approved additional privacy protections, which amended the CCPA, and it's now known as the California Privacy Rights Act, or the CPRA. Companies who do hold data on California residents or have employees in California really should make sure their privacy policies and practices do meet this updated law, because there's quite a few new updated changes to what can or can't be done with the data. And then likewise, employers in Virginia, Colorado, Connecticut, and Utah make sure that their company's policies also encompass protecting their employees' personal data. While California law may be stricter, employers in these other states really should be sure they're classifying and protecting their employee data properly. And then on the 29th of this month, so yesterday, Iowa did pass their data privacy law. So that goes into effect January 1st of 2025. So there is some time to implement that. Iowa is similar to Virginia, Colorado, Connecticut, and Utah, but that one has just passed as well as of yesterday. So that one will be going into effect in 2025. So as we said, these are becoming increasingly more states are passing these privacy laws. So one of our predictions has just come true now. So all right. So next, the industry is currently tracking 32 bills related to court access. And what this is being able to access records in the courts for background checks or for people who want to access criminal records. So it continues to pose challenges. Several courts in California have removed the dates of birth from the public access, which is making it very difficult to confirm records for applicants. So court records no longer have easy access to the information, which is delaying criminal records, and it's increasing the turnaround significantly. Researchers need to submit requests directly to the court clerk, and the court clerks then look up the file and give the information back to the researcher. Many courts are also limiting requests for how many can be made daily, which is further slowing things down. So a person may be only to request 5 or 10 at a time and then get back in line and have to keep submitting them that way. And PBSA has really been working diligently with the courts to help get legislation passed, but progress is very slow in California and probably won't be moving forward for another year or two. So that one is slow. Michigan has seen some improvement, but there's still some delays due to the date of birth issues in the courts for the same reason. So Cook County in Illinois, that covers Chicago, one of the big cities in Illinois, they've had limited access to terminals for researchers to locate records. So while there's been some improvement there, records are still taking a little bit longer to get back to us. South Carolina removed dates of birth from court records. You're sensing a trend here. The ACLU filed a suit against South Carolina judiciary, which was just recently decided in the ACLU's favor. So dates of birth are going to be coming back into those court records, but it's going to take some time to get that done. And then North Carolina and several other states are undergoing record transition projects. While it's ultimately going to speed up access to records, the transitions have slowed things down. And sometimes when things transition between system to system, there is some issues with data being transferred over properly. So we'll be keeping an eye on those areas as well.
All right. Well, look at this colorful map, huh? It's pretty colorful. What does it all mean? We're going to talk marijuana. So marijuana laws, we're going to continue to see that. That is not going away anytime soon. So on the map that you see in front of you, the orange represents states that have legalized recreational marijuana and medical marijuana. And then the green states represent those that have legalized medical marijuana. The remaining 11 gray states represent those that don't have current laws. And then the most recent ones that we've seen pass are Rhode Island, which was effective of May 25th, 2022, Minnesota effective July 1st of this past year. They legalized THC edibles, drinkable products, and they're looking to expand that law here in 2023. Missouri was effective December 2022, and then Maryland effective goes into effect July 2023. So like we discussed earlier, local laws are never identical, right? So you need to review them for exceptions, definitions, but here are the states to really be aware of for protecting off-duty use of THC. And remember, there are no tests available on the market today that shows someone is impaired or high on THC. I wish I could come up with that test because I'd be a gazillionaire, but obviously it's a hard test to come up with. So I don't think we're going to see that anytime soon to check for impairment. So we got to kind of deal with the laws that are getting put in front of us and knowing that testing is not a perfect solution. So Washington, D.C., as of July 2023, and then California as of July 2024, they're joining New York, New Jersey, Connecticut, Montana, Rhode Island, and Missouri. So that's really tricky for testing for THC in those areas. And now you probably have some questions coming in saying, what about safety sensitive positions? Again, every law is a little different, so you got to look to that. If it's not a federally regulated, like a DOT or FAA, you gotta be really careful because the definitions vary widely. So be careful there. And then what about Maine and Nevada? So in Maine, the voters passed an initiative in 2016 to protect workers, but the legislature since repealed that, and they have a commission to study it. So kind of in a wait and see there. But Maine's a little tricky with their drug testing. For any of you who are doing it there, you got to go through the Department of Labor. They got to approve your drug testing. So if you've already removed THC, you know, are you going to go back and add it? Probably not. And then you have Nevada, right? So that's a tricky one too. So they had a law, excuse me, protecting applicants, and it went into effect 2020. But then the Nevada Supreme Court came in August of this past year and declined to recognize recreational marijuana use as lawful activity for purposes of the state law. They reasoned that while recreational marijuana is legal in Nevada, it's illegal federally, which we all know, right? Unless, and we know in Congress right now, right, they can't get along on anything. So I don't think we're going to see legalization of marijuana at the federal level. So that they stated that if the legislature meant to require employers to accommodate the use of recreational marijuana, they should have done it, right? They should have called it out specifically. So what does that mean? So right now it's kind of up in the air in Nevada, because that's a court case. It was at the Supreme Court, but you know what's going to happen. The legislature is actually going to just fix the wording and make it work. So on what they wanted. So again, can't stress enough the takeaway here. It's confusing. The laws are crazy and they're different all over the place. So make sure you brush off that substance abuse policy and get that fixed. And just to add here, just because we're in marijuana, New Jersey came out with some guidance this past year. So checking for impairment, or if you think someone's been using, while at work, they have a great, it's called The Wire. And I'm sure we can get that to you, Jeff, to get out to folks if they want it, but it's a great checklist for employers. We've given it to HR professionals and consultants to use because it's a great tool to use. So, not often that you get something from a legislature that's useful, but in New Jersey, and if you are in New Jersey, that is pretty helpful. So, all right, let's get off marijuana. Because we could be on that one all day. All right, so our next prediction is staffing challenges and remote work impact screening standards. So remote hiring, which laws apply. So I'm sure most of you are dealing with remote worker situations right now. And as I mentioned earlier, right, what laws apply? Is it the laws of where you are the employer? Is it where they're working, living? Again, we can't give legal advice, but most times you got to follow the law on where they're actually sitting and working. So you really want to be careful of that. Why? Because I know you have so many things to worry about with employment law, right? So this is just one little tiny subsection, but I will tell you with background screening laws, the drug testing laws out there, they vary. So be careful with your remote workers, make sure you're looking into that. And then also, like, what notifications and disclosures do you need to provide? Like all laws, these also vary by jurisdiction. So, and also the size of the employer and things like that. So I'll just give you an example. San Francisco has a posting requirement, and that applies to employers with 5 or more employees, whether or not they're in San Francisco. So it's just a matter of the total employees that an employer has. If they have one person for 8 hours a week working and going into San Francisco, they have to follow that law for everybody, which is kind of crazy. But that's San Francisco, right? And then our latest law is Gainesville, Florida. They require specialized notification of adverse action, but only applies if you have employers who have 15 or more employees who work in Gainesville. So you see how the differences go there. So those are just 2 examples. And like I said, every single one is a little bit different. So what do we think is best, right? So again, did I mention that's not legal advice? Okay, I'm just going to say it again. Not legal advice, but here's what Christine Canine says. As the employer, you're required to provide the disclosures or notifications, not your background screening provider, although we all assist, right? Orange Tree in their system is assisting and helping you, and so is Higher Image. But the screening provider is just the conduit, right? So you're the one responsible for everything. So talk to your provider, make sure that you're getting those forms. And then if you're not working with one of us, you can come to Jeff, ask him, take a look at things. I'm sure he can help you out and say, what Orange Tree can do for you. So we tend to be conservative in this area. Like within our system, we have the applicants certify where they live and work, and we just give them all the documents that they need. So if they're living in one spot, working in another, we're going to give them all the disclosures. So that's kind of the way we look at it. You could talk to a lawyer and say, no, you don't have to do that. So again, kind of look at that and see what you do. But also it's just also in the criminal record reporting, right? So where this person's living and working, like just recently Massachusetts, a couple of years ago, they updated their ban the box, fair chance laws, and they limited how long you can report misdemeanors. So most misdemeanors you can only report for 3 years. So if you're in a different state, now you can't get maybe misdemeanors for a longer period in Massachusetts if the person's living there. So just things to think about. So for drug testing, make sure again, your substance abuse policy, but you also want to cover THC specifically and, thinking about the medical marijuana and all that kind of stuff. You want to say it's, you don't want it on at your office and things like that, but just be careful how you're wording things because you got ADA issues with the medical marijuana. So be careful of that. And then also I didn't touch on the use of credit checks. That requires different disclosures too and different reasoning. So just be careful if you're doing credit checks in your multi-state as well. So I will pass it back over to you, Laura, for the next prediction.
All right, criminal justice reform. Yay. It's impacting more states and employers right now too. So be aware that there are currently 44 bills related to expungement currently pending. So 44, that once again, a lot of bills related to this. So criminal justice reform has impacted other areas of the country over the past year. So Atlanta, Georgia, they very quietly passed this Fair Chance Initiative late last year, and it amended their anti-discrimination law to give broader protection based on criminal history and gender expression. But by doing so, they've effectively made criminal history status a protected classification, the same as race, gender, religion. So be aware of that. California law from 2018 required the state to clear cannabis convictions effective of March of this year, but some of the states had been slow to work with it. So right now courts are required to, by March 1st of this year, so a few weeks ago, they were required to update their records and report them to the Department of Justice. As of July 1st, the Department of Justice is going to be required to ensure these records have been updated. So there's still maybe some marijuana convictions floating around in California, but they should be getting those taken out of the system. Arizona's second chance law went into effect January 1st. This means those in Arizona can petition the court to seal their records if all of the terms of their sentence has been completed. Arizona's had this provision on the books since 2020 to have some records expunged, including those for minor marijuana offenses, but this is not going to allow a broader classification of cases to be expunged or sealed. Colorado's Clean Slate Act went into effect last August, and that once it is something that will automatically expunge or seal nonviolent offenses. So once those are done through the system, they're automatically going away. You won't see them. As Christine mentioned, Gainesville, Florida passed an enhanced ban the box law in December. So in addition to not asking about criminal records until later in the process or after a conditional offer, it adds additional compliance requirements. So if you decide to take adverse action on someone, you have to give the reason based on those records. And then on the federal front, President Biden announced in October that minor marijuana convictions at the federal court level will be pardoned. This only affected about 6,500 records in the federal court system. But a very important note with this is these were pardoned convictions. They're not expunged or sealed. So these convictions still will show, but they were pardoned. You really shouldn't be using them. So make sure you're working with your provider so they aren't giving you records. So I know Orange Tree and Higher Image both are working with that, but those records that have been pardoned shouldn't be a part of your background check any longer.
Great. Thanks, Laura. And then for our next prediction, applicants continue to want more out of the hiring process. You all know that for sure, right? So what we see here is they don't want to enter information into multiple systems, right? So they want integrations with your ATS or HRIS system. It's really important. And as Jeff mentioned, they're building those integrations. We have some too. So it's important to have the systems talking together. Do they really have to enter, 2 times where they worked or where they graduated school? So these integrations, what happens is, you kick off the background check, it goes right into the Orange Tree system or the Higher Image system, and the applicant's information automatically goes over. They don't have to re-key things in. They're really looking for that. They're getting a little more demanding, your applicants, and you don't blame them. Everyone's in a hurry and everybody's rushing. And then also most applicants, they have a smartphone. They want it to be a mobile process. So texting is important to them. Not everybody might have access to a computer, or it's just not as convenient for them. So the ability to complete the screening process or other processes that you might have on a mobile device is critical with today's applicants. And then I think customize and communication, they go hand in hand, right? One size does not fit all. So work with your provider, make sure that you're able to communicate with your applicant that the process meets your specific needs. So for example, you might have different screening requirements for different positions. So you might need a different notification for one position versus another. And the screening systems a lot of times can change the notifications and what's required based on those packages or whatever those searches are that you're requiring. So you can really customize emails or texts or things like that. So talk to your provider about that. And then we all know communication, right? It's critical. It's critical, in every aspect of our life, but we find this more and more with applicants, like they might not be told things up front or they don't understand. And, they might get frustrated with your background screening provider because we're asking them for more and more information. But you want to make sure that you're setting the expectations up front for them. For example, if you need 10 years of employment history, but the applicant doesn't supply it, what's going to happen to them? What are you going to expect from them? Let them know so that they know up front and that they don't feel like they're being harassed by your provider. So review that process, determine if the requirements are still needed. We've talked to a lot of our employers too, when they have stringent rules on what they want for employment verifications, asking them if they want to maybe ease it once we start hearing that there's a lot more applicants that are getting frustrated in the process. Again, this is where it's a great opportunity to talk to your background screening provider and just talk it through. Hey, we've been doing this for a number of years. Do we still need it? Do we not need it? Sometimes you do, I know healthcare industry, right? You really do need that information, but some other industries, maybe not. So that's just an area that I would say it's going to continue to have, your applicants wanting more out of the process and better communication.
All right. So as we mentioned earlier, AI is in the crosshairs in regard to hiring and retention of employees. The EEOC is really taking a hard look at AI, and they issued a technical assistance document addressing AI and the ADA, or the Americans with Disabilities Act. The EEOC is looking at any system that uses AI to screen out any applicants, including ATS programs, applicant testing programs, and things like that. From the hearing that they held in January, they're approaching it as if all of these systems are biased and that they're going to be discriminating against others. So if you use any system that automatically routes or excludes an applicant, you're going to want to look at them to have them vetted for discrimination bias. You want to work with your providers for those to determine where you can address these issues. Are there things that you can do within the system to make them better and to take away the discrimination bias? And then in addition to the EEOC, New York City passed a law which goes into effect April 15th, and that's regarding the use of automated employment decision tools unless bias audits are done and notice requirements are met. So you're going to have your systems audited for bias, and you're going to have to provide notice to your applicants. The law was set to go into effect January 1st, but it was pushed back to allow some more time for a second public hearing, but it's now going into effect on April 15th. So if you're hiring in New York City and use any type of automated process for hiring, you really want to make sure you've reviewed your automated decision tools and that make sure they've been sufficiently audited for bias and that you are providing notice to your applicants. And then, as one of our predictions, another one has come true, unfortunately. There was a suit filed recently, it was in February of this year, against Workday, one of the big ATS. It's out of the Northern District of California. They are basically, the lawsuit boils down to AI favors those outside of protected classes based on the algorithm. So they're stating that because the algorithms and the systems were put together by humans, there are human bias. So they're automatically going to discriminate against people who are part of a protected class. So this one was just filed. We're not sure how it's going to go, but as we mentioned, these are the types of things that we're expecting to see more of this year, unfortunately. Workday is going to be the first one. I think there's going to be others. So if you're using anything with AI as part of your background screening process or part of your hiring process, you really want to get it checked out.
Yeah, and Laura, I think, it's a great point. I think this is an area we're gonna see a ton more lawsuits, and the
Yep.
EEOC is like, I don't a dog with a bone with this
Yeah.
AI, and rightfully so on some respects, but what another takeaway for you all is they're really telling you, the employer, you're responsible to know. You can't just say, oh, I use Workday
Mhm.
or, whatever, or UKG or
Exactly.
any of the other platforms. You have to know what the algorithms are. And I know a lot of times they're not telling you, right? You just, listen, you can't look at 500 resumes. You just say what your criteria is and they're whittling it down for you. But
Mhm.
start asking those questions, ask them how they're doing it. To determine, on your own if there's any bias, which I know that's not easy either, right? And we gave this I think, was it last year or the year before? I don't even remember, Laura, but we had the former EEOC commissioner
Mhm.
do a webinar with us, and she talked about this AI stuff, and had one of our employers say, oh wow, I had to go back and change something because, and it, innocently enough, right? They had a community that wasn't on the bus route. They have a lot of folks that come to their plant via bus. And it wasn't on a bus route. So they excluded certain zip codes,
Mhm.
just making it out of the commuting thing. But, they went back and changed it because they realized. So really, really important area. And I think we're going to see a lot more. So
Yeah.
just don't sit back and think the Workdays of the world have it. They are going to be the target, but you're next. And
Yeah.
the EEOC is the one saying you, the employer, are responsible. So just like with the background screening laws, you, the employer, you got to take ownership, and it is your responsibility. So really important stuff. So thanks, Laura, on that
Thank
one.
you. All right, so pay transparency, and they are altering verifications of prior work history. So as we mentioned, these are looking to be something like the new ban the box laws, where these are starting to proliferate. Several jurisdictions have enacted laws requiring employers to post pay ranges or to provide them to applicants upon request, depending on how the law is written. These laws were aimed at protecting employees and helping close wage gap, especially on gender or racial or other protected groups. And as Christine mentioned earlier, these are good, well-intentioned laws. Unfortunately, they're just not happening the way that we hope they would. I know there are companies in New York City right now that are posting, they have to list a pay ban. And we saw one from, it was like 85,000 to 385 million. Really? Come on, just don't be idiots. So be realistic in what you're doing there. Sorry. But yeah, so many companies, even in those states where it's not requested, have begun to follow suit. Your employees are working for pay. So you need to let them know what they're going to be making or what they could be making, what ranges are, and have an idea of what your ranges should be and how you would pay someone. So, but then also laws vary by jurisdiction, and asking employees what they made at previous jobs. So you want to make sure, are you even allowed to ask for prior history? Are you even allowed to get it verified during the background screening process? So you don't want to run afoul of laws in that way either. So you can see there are several states out there that enacted these laws last year. California and Washington State went into effect beginning of this year, but there are several areas that have the pay transparency laws. There's other states that have the laws where you can't ask about salary history. So pay attention to that. And as Christine mentioned, there's currently 17 bills pending in this area. So it's really something to keep an eye on.
Yeah, definitely. We're not seeing this go away at all.
Nope.
So, and again, well intended, but causes a lot of problems for you, the employer. All right. So we were talking about, as we were hitting on these slides, telling you about how many bills are pending. This is currently, as I said, I attend weekly meetings with the Professional Background Screeners Association government relations team. So just to give you an idea of how busy it is out there. So this is all the state and local laws that we're tracking. So employment screening being the largest, marijuana right up there, expungement having to go with those clean slate laws. So that's where we're seeing things lie. And again, this changes, goes up and down and fluctuates, but there's a lot happening. Will they all pass? No, of course not, right? You know how that goes, but we definitely expect to see a number of them that will. So that's how we track it. And then also at Higher Image, we have a resource library, and we'll coordinate with Jeff and the Orange Tree team, getting that over and coordinating with them to, but we offer resource guides for ban the box laws, restrictions on the use of social media, guide for recreational marijuana, as well as medical marijuana, resource guide for salary history, and then the use of credit history. And then we also have a resource guide for restrictions on who can pay for the record check. Sometimes you want the applicant to pay, some states you're not allowed. So we offer all that on our website, but again, we'll coordinate with Jeff if any of you want or need that. And then I think, again, Laura and I always feel it's important on our webinars to just give a little like shout out to compliance reminder, FCRA 101, because it is your responsibility. So I'll kick it back to you, Laura, to get into the nuts and bolts of it.
All right, yeah, we'll hit through these and then we'll there's a few questions are coming in, so we'll get to those as well. So FCRA 101. So if you're going to do a background check on an employee, you have to disclose in writing that the person will be the subject of a background report as part of the employment process. It has to be, the disclosure has to be a standalone document. There are still lawsuits going through on this, and these become class action lawsuits, which are bad. You don't want to be part of one of those. So the disclosure has to be a standalone document. Also, for employment, if you're going to do a background check, you have to have the authorization signed, and it has to be an actual signed authorization. It can be electronic, it can be paper form, but you have to get the employee's consent to do a background check. If after the background check is done, you decide maybe you don't want to hire this person, there is an adverse action process you have to follow. It's a two-step process, and if you're not going to hire someone, both steps have to be followed. Can't stress that enough. So first step is called the pre-adverse action. You have to notify the applicant, you have to give them a copy of the background check, and you have to give them a copy of a summary of your rights under the Fair Credit Reporting Act. All of that has to go together to the candidate. Once you send that over, you have to give them sufficient time to dispute or to provide additional information. The FCRA is silent as to what a sufficient amount of time is. So we usually say at least 5 business days. Most people are looking at 7 to 10 business days. So you want to give the applicant time to review the information and to dispute the information if need be, before you take the second step, which is adverse action. The adverse action step is usually just a single letter explaining that you're not going to move forward with hiring them. But if you're going to not hire someone based on a background check, it is a 2-step process. We do get questions from time to time on this is, if I send the pre-adverse action out, do I have to send the adverse action if I decide to hire the person? No. If you send the pre-adverse action out and they either give an explanation or they dispute the information and it turns out something was incorrect, you can still hire the person. You don't have to send the second step letter if you're going to hire them. And then something else that we also hear frequently is, if you want to talk to your candidate about their background check, that's fine. But if it may be something in the check that's going to cause you not to hire them, do the pre-adverse action step first. Send the letter, give them a copy of the report, give them the FCRA summary of rights, put that all together, give it to them, and then have a conversation with the person, because you're covering yourself, you're making sure that everything is good, you follow the law the way it says. So if there's a chance that you may not hire someone, definitely follow the pre-adverse action step, and then if need be, follow it up with the adverse action.
So Laura, I'm just going to reiterate that because, maybe hearing 2 voices say it, because that's really, we hear it all the time, and
Yep.
You all are moving so fast and you're trying to hire and you got a class starting and, oh, you didn't pass the background check. Let me tell John not to show up on Monday's training class. So you can tell him not to show up, but you can't say we're not going to hire you, because there's a 2-step process. So you have to give him a chance to dispute. That's what it's all about. So you can't even just send a letter and say we're not going to hire you, because you got to wait that sufficient amount of time.
Yes.
So again, you can have the conversation, but as Laura mentioned, first kick off the letter, which could be an email. So I'm sure the, Orange Tree ProSource system, kick off an email. In our system, you can kick off an email. So it goes pretty quickly, right? But still don't tell them you're not hiring them. Really important, because they have a chance to dispute it. We've seen that, dads use their son's identity, right? And the son doesn't even know he had a background check, a criminal record. So things happen sometimes, right? So make sure you're really careful not to overspeak to your candidate. I can't stress that enough. And the one other thing I'll just add on there is, not yet, because they've already have to make another change, but the Consumer Financial Protection Bureau is issuing a new summary of rights under the Fair Credit Reporting Act. Your background screening provider should take care of that for you. But again, how many times am I going to say this? It's your responsibility. So just make sure you're part of the conversation and that you're aware that that's happening. They did come out with a new 800 number, right? So
Yes.
you guys will laugh at this. This is the government 1-800 and they did XXXXX, however many X's. They didn't give a number. So we know there'll be another change and it doesn't go into effect yet. We have some time. So
Yes.
just know that that's coming, but we're waiting for them to correct it. So gotta love the government, right?
Yeah.
All right.
Thank you. All right. So back in April of 2012, which is now 11 years ago, this was like a huge sea change when this happened. The EEOC came out with their guidance in regarding considering criminal records and how to use them. So the biggest thing they want you to do is to do an individualized assessment. You shouldn't have a bright line policy simply saying, if you have a felony, we're not hiring you. If you have a misdemeanor, we're not hiring you. You really want to look at all of the different areas around the criminal offense before you make a decision to not hire someone. So things you should be looking at are the facts and circumstances around the offense. So was it someone who was trying to protect someone else, or were they were they doing something they really shouldn't be doing? So you want to look at that. You want to look at the number of offenses that the person was convicted of. If they were convicted of one offense 10, 15 years ago, does it really matter? It depends on the offense, of course. But if there's a history or a pattern of a number of offenses, then you might have a little bit more of leeway in saying you don't want to hire someone. You also want to look at the time that's passed since the time of conviction or the release from prison. I don't think there's one of us out there who wasn't young and stupid at one time. So if there's a record from when the person was 18, have they grown? Have they shown change? Have they done stuff since then? That's wonderful. Then you may want to consider still hiring the person. You want to look at rehabilitation efforts. Have they gone to school? Have they had additional training? Or are they in a job position that is the same or similar to what you're hiring them for? And they've done a good job with it. So you want to look at those types of things, including the length and consistency of the employment history before and after the offense. They had a decent history before and they've had a decent history afterwards. Hopefully they've learned from what they did and they won't commit the crimes again. So look at that. Look at employment or character references or other information regarding their fitness for the particular position. Once again, you can talk to their parole officer and see, have they shown remorse? Are they doing anything to really grow and learn from what they've done? You can take a look, see if the person was bonded under federal or state or any type of bonding program. If they are, it means, okay, probably okay to hire them. And then evidence that the person has performed the same type of work post-conviction with no other incidents. So just because someone has a crime in the past, are they the same person? Probably not. I mean, you can still consider the factors. I mean, some of the easy ones are if they currently have a DUI and they're a driver, probably might have you can have a conversation with the person and may have something to look at not to hire them. If they're going to be driving for company position or company business. But if it's somebody who has a DUI who's going to be working out as a machinist in your company and they aren't going to be having any driving types of position or any type of, like they're not driving a forklift or anything else like that for work, you want to weigh those types of things before you just say, nope, we're not going to hire someone.
So Laura, just, I like to always butt in, right? So
Uh-huh.
a couple things on this slide that stand out to me. So when I'm seeing all these fair chance initiatives pass at the state and local level, so EEOC guidance is just that, it was guidance, wasn't really
Yep.
the law, although we all tend to kind of follow it. But all these fair chance initiatives, they are really codifying this. They're putting these
Yes.
facts and circumstances within the law. So then it makes it the law in those states. And so we're seeing that a lot of the fair chance laws. What I recommend, again, not legal advice, just us who work in this stuff every day. If you want to look at your background screening policy, since you're going to be dusting off your substance abuse policy, right? We're all going to do that. If you want to look at your background screening policy, it's been recommended, tip your hat to the EEOC by putting you don't want a blanket policy. You're not going to hire someone with a criminal record. These would be great steps to put in your policy that you'll consider these things when and if a criminal record comes up. So that's my little 2 cents on that. And then Laura, I'll let you go over some of the common violations, which you kind of covered, but I always think it's great to mention them again.
Yep. These things are just not going away, unfortunately. The FCRA is pretty straightforward with what you should or shouldn't do, but we're still seeing companies that are not following what they should do. So you have to provide notice to the job applicant or the employee that a background check is going to be done. You can't just sneak behind their back and do a background check. If you're using an agency such as Orange Tree or Higher Image, you've got to give them notice. You've got to get their signed authorization if you're doing a background check. You've got to do the pre-adverse and the adverse action procedure if you're not going to hire someone. And then when you, especially with the pre-adverse, you've got to give them a copy of the report and the FCRA summary of rights. So simple things to do, but in the course of day-to-day work sometimes do get missed. So make sure you are doing those things. Other things that we're seeing are still people are embedding the disclosure and authorization in job application. As I mentioned, the disclosure has to be a standalone document. It can't be part of anything. It has to really be on its own, on a standalone page, nothing fancy, nothing else with it. Just make it the disclosure for the background check. And then the authorization also should be not as part of your job application, because a lot of job applications follow the next one, including a waiver or release of liability or a waiver of rights. So you truly want your background check authorization to be just dealing with the background check, nothing else. As we mentioned, the FCRA summary of rights is being updated. The new ones don't go to be used before April 19th, and you have to use them by next March of 2024. So everything will be updated before then, but make sure you're not using an outdated form of summary of rights. Prior to this one, they were last updated in 2018. So make sure that you're using things that are up to date. Talk with your provider, Orange Tree has updated forms, so do we. And then make sure you're following state and local laws when you're doing a background check. As we've mentioned, people are working remotely. You also have employees, you may have a centralized office, but people are working in different locations. Make sure that you are following the laws where the person is working, even though that's not legal advice. Make sure you are following the laws where it's going to affect the applicant, is basically what it boils down to. As we mentioned with part of the EEOC, certain jurisdictions, Los Angeles, New York City, they have very specific rules you have to follow if you're not going to offer someone a job, if you're doing a background check. I mean, so make sure that you are following those state and local laws, because they will come after you. Not following state law in California, in many cases, if you're violating their version of the Fair Credit Reporting Act, it's a $10,000 fine per applicant. So just make sure that you aren't doing what you shouldn't be doing.
So you can probably tell we're pretty passionate about all this stuff. So sorry, Jeff, if we haven't left too much time for questions. I don't know if you want to hop on, if you had any that we can quickly answer and let everyone know how they're going to get their certificates.
You know, we do have a question here,
Okay.
and there it is. So we have a member of a medical staffing organization, healthcare, if that's not a little bit redundant, and they're looking to fill staff in nursing homes in the state of Illinois. And they had a temporary employee show up at a facility smelling like marijuana, and they had the external appearance of looking high. This individual has been blocked from working at that facility because of this situation. So then the question, that's the backdrop to a question, is this okay with the laws that are coming into play? As part two, can this individual be terminated from that facility due to marijuana use?
So I think,
Yeah.
well, number one, we can't give legal advice, and we can't give, any legal advice on a specific instance, but Illinois, it goes back to the testing, right? So, and this goes for other states too. If you have reasonable suspicion, that's a little different. And then you have a test that you can give someone. I know I have attorneys that have told me, do you really want to do reasonable suspicion testing? Because in some states it becomes kind of your problem, right? If they come back and it's marijuana. So sometimes it's just for cause, right? There's other things that they're showing. So you might get around the drug test in that way. And can you terminate them? I mean, it depends, I mean, I'd say yes, right? But you want to make sure you have that you're following kind of the steps and you're looking at that Illinois law. Lord, are you remembering, I don't have it in front of me, the Illinois law with the drug testing?
I think you're okay to test for it. We can double check on that, but I think you're okay to test for reasonable suspicion like that. But one other thing to keep in mind too is just the smell of marijuana isn't necessarily enough to say someone has been using marijuana, they may be around someone else who's using it as well. So their clothes may smell like it. So that's something to be aware of. And I know Christine mentioned that New Jersey form that they have. It's great because it goes through a whole lot of different things that you can observe or see or deal with if you really are going to move forward with a reasonable suspicion. So
Yeah, and Jeff, we'll get that to you because that might be a good thing to get out to folks. It's from the New Jersey. I think that might help in this situation too. But you know,
Terrific.
you could talk to 3 different attorneys and get 3 different pieces of advice. But a lot have told me like, do you really want to do reasonable suspicion testing? So
Well, a lot of times it's good to get 3 opinions on everything anyhow, because
Yep.
typically there's 2 out of 3. In this case, you might actually get 3 different answers. So,
right.
you know, we appreciate the question and we appreciate the situation you're in, given a variety of circumstances surrounding marijuana. I think you mentioned it earlier, Christine, in the course of the presentation, you'd be a gazillionaire. And that just sounds like a lot of money. If you could figure out a way to come up with an impairment device that would be accepted within, I suppose, court law, as well as in practical terms amongst all the communities that have a stake in being interested in such things. So I think that's really, that's the top of our hour. That was a great presentation. I mean, there's more to talk about in all those topics. So for all of you who would like to learn more, and reach out to Orange Tree Higher Image. We're happy to continue this conversation, maybe get a little more specific. There's some things that in a broad presentation like this that are difficult to get into all of the nuances and details, but sometimes one-on-one it can, and perhaps we can just learn a little bit more about some of those details and some of the challenges that you're facing, which allows us to also give a little bit more specific information on your behalf. So with that, we will follow up with an email communication, and it will have a link to today's recording. I have a link to the handout if you haven't already had a chance to download that. There may be another piece of collateral in there too. And then also for all of you who have qualified for continuing education credits, that information will be in the body of that email. So without any further ado, I'll just say thank you very much for your time. Very much appreciate your business. We'd love to have the opportunity to work with you if we haven't yet had the chance to do so. Have a wonderful rest of your Thursday. Thank you very much. Thank you, Laura.
thank you, everybody.
Thanks,
Bye-bye.
Jeff.